Hey everybody, happy Tuesday morning. This is Curtis Bryant from the Citrus Insider. Today we're going to jump back into the Tuscany vote and discuss a little bit about what happened during that vote and a potential conflict of interest with the Rebecca base. So let's get into it. Alright, so we all saw the meeting on Tuesday. There was a vote about Tuscany Ranch. This was approved by the VOCC, a 3-2 vote. The 3 people voting yes, Commissioner Davis, Commissioner Kennard, and Commissioner Bays. 2 people voting no, Commissioner Finnegan and Commissioner Barrick. Now, during this, I found a potential conflict of interest. We're going to talk about that today and how Commissioner Bays probably shouldn't have voted in that hearing, and we'll discuss why. First thing I want to show you guys is I want to show you guys a video. Earlier in that meeting that day, a citizen expressed concern about Commissioner Bays and asked her to recuse herself for a separate incident in a separate hearing that's coming up later on. So we're going to hear a reply from Commissioner Davis, her interpretation of the law and why commissioners can't recuse themselves.
Joe, you want Commissioner Bays to recuse herself. I just ran into this on social media because of the issue with Inverness Airport. We are not legally allowed to recuse ourselves. Literally, if I want to skip a vote, I would have to call in sick, which I've done exactly once when I was monstrously ill. I don't shirk the hard votes that I have to take. And man, there's a lot of votes that I would rather not be here. Okay, but we are legally cannot recuse ourselves unless we have a fiduciary interest in the vote at hand. Okay, so she can't, just because you don't like something someone says, they are not allowed to recuse themselves.
All right, so we heard her say that they can't recuse themselves from votes, and to an extent that is true. Most votes, they have to take the vote for that. However, let's read Florida Statute 286.012. This is the voting requirement at meetings for governmental bodies. Now, the first part of it is saying that they have to take a vote, a member of a state or county municipal government, board, commission, or agency who's present at the meeting of any such body at which an official decision, ruling, or other official act is to be taken or adopted may not abstain from vote in regard to any such decision, ruling, or act. So saying that you can't, she's correct, that you can't abstain from a vote if you were at that meeting. However, here in yellow, unless, with respect to any such member, there is or appears to be a possible conflict of interest under 112.311, 112.313, 112.3143, or additional or more stringent standards of conduct, if any, adopted pursuant to 112.36. So they're saying that unless there's a possible conflict of interest under those statutes, we'll talk about those here in a second, they are able to recuse themselves under that. More than that, down here at the bottom, it says, if the official decision, ruling, or act occurs in the context of a quasi-judicial proceeding, a member may abstain from voting on such matter if the abstention is to assure a fair proceeding free from potential bias or prejudice. So, Commissioner Davis is true. It is correct that you cannot abstain from voting on a regular item unless there is a conflict under these statutes here. However, with a quasi-judicial hearing, it carves out exemptions to that rule, and they may abstain just because of a potential conflict of interest from that to avoid potential bias or prejudice. So they don't have to take a vote on a quasi-judicial case if they want to assure that there's a fair proceeding free from those potential bias or prejudice. Further, here's some voting conflicts. This is 112.3143, so you'd mentioned that in the previous statutes that this is a reason for someone to not take a vote. It defines public officer includes any person elected or appointed to hold office in any agency, including any person serving on an advisory body. So public officer in this case would be a county commissioner. Section C there, a relative is defined as any father, mother, son, daughter, husband, wife, brother, sister, father-in-law, mother-in-law, son-in-law, daughter-in-law. So basically anyone who's related to that person is considered a relative. Now, let's take a look at this statute. This is 3 Section A. No county, municipal, or other local public officer shall vote in an official capacity upon which measure which would inure to his or her special private gain or loss, which he or she knows would inure to the special private gain or loss of any principal by whom he or she is retained, or to the parent organization or subsidiary of a corporate principal by which he or she is retained, other than the agencies defined by 112.312. Now, here is the key part of this. Or which he or she knows would inure to the special private gain or loss of a relative or business associate of the public officer. So, key there, saying that the person cannot vote on something if it would bring potential loss or gain to that particular individual, or to a relative of that individual. So there's the state statutes. By law, she is supposed to remove herself from the vote if it is going to give a loss or gain to a relative for that. Black and white state law. Now let's jump into why this is an issue. So this is going to be the video from the BOCC meeting. If you want to go to the YouTube channel for the county commissioners, this is the exchange that takes place at 8 hours, 27 minutes into that meeting. She is going to talk about right-of-ways and things of that nature, and her preference of the county buying right-of-ways versus borrowing them for special projects like widening 491.
And probably, one thing on easements, if we got down that road, what I don't want to do is I don't want to pay for temporary easements. If we're going to have to, if we're doing 4 lanes and eventually we want to go to 6 lanes and to do 4 lanes, we have to pay for temporary easements. That costs us almost the same amount of money as it does to buy the right of way, and I get that makes me very nervous when we start talking about.
Temporary easements are usually to blend the roadway with existing infrastructure or driveways and things like that. So it's not something we normally hang on to afterwards. There's not a purpose for us to have it afterwards, but we have to have them to be able to complete the construction.
Right, but right now we're doing that on 491 right now.
Like a slope easement or something that's permanent, those would be permanent easements.
Right.
But temporary construction easements are for very specific purposes in certain areas.
Well, I'm referring specifically to the section of 491 that we're building right now, where only a certain amount of lane, or the board required just enough to build 4 lanes. And then we had to pay for temporary easements, and if we would have been better off having as much land to do 6 lanes in the future than to pay for temporary easements. So that's.
I don't want to be your eminent domain attorney, but I can tell you when you go to the board for a right-of-way or to an order of taking a hearing, you have to testify that when you're done, the public purpose for that will fit within that, and having a temporary easement, a permanent easement outside of what's required for the roadway could jeopardize your order of taking hearing if a lawyer made that point.
So anyway.
Am I right?
I think that's more just for us internally, like,
Gotcha.
I mean, I'd rather see us, if we're gonna have to do things like that, to get to 6 lanes, get by right away or whatever we gotta do. And then as far as impact fee.
Now, this is important because earlier in this meeting, they were talking about the 491 widening, and Commissioner Finnegan brought up the point that we can ask them for more help with 491. Currently, with the development agreement that was in place for Tuscany, they have to provide us 30 feet of right-of-way on their side, so the east side of 491, for the duration of the project, which is about 1.4 miles. As a quote-unquote concession, they included an additional 20 feet of right-of-way, so basically 50 feet of right-of-way was going to be given to us on the east side of 491. What you're seeing here is that as they're talking about widening 491 in the future, Commissioner Bays is mentioning that she would rather see the county buy the right-of-ways and buy the property rather than getting renting easements, so to speak, to give permission to run the utilities on the property, and then the property goes back to the property owner. Now, why is this important? Why does all this matter? And why does this why do I mention this when we talk about conflict? Is this next thing here?
And
this is a property appraiser map of the area that is in question here. This is 491. So you have 491 running here. This is Hampshire Boulevard there in Beverly Hills. This is the Tuscany project. This purple or pinkish color here, this is property that Commissioner Bays' husband, Mike Bays, owns with a partner of his there. So they're talking about doing the right-of-ways. As I mentioned, Tuscany, as part of their development agreement, is going to give us 50 feet of the right-of-way on this east side of 491. Commissioner Finnegan asked for more. She said that they could give us more right-of-way, which doesn't require us then to get right-of-way on this side of the west side of 491. So if they were to donate more land for us, because obviously there's more land here, Tuscany could donate the land. We don't have to pay these property owners on this west side of 491. But that was knocked down during the meeting, and they said, I think Commissioner Bays in particular was mentioning that we needed to make this west and east side so it stays kind of, the road doesn't have to shift to the east there. But there is plenty of room here if we wanted to negotiate that to where we don't have to buy the easements and things from this west side. But again, this is property that Commissioner Bays' husband owns. Also during this meeting, we heard them discuss the intersection here at Hampshire. As this project is built out, they will be required to put a stoplight here. So had this project been denied, the stoplight that is going to come here likely would not come for a couple more years unless the county wanted to pay for it. Now with this project, Tuscany Ranch is going to have to put this stoplight in here at some point as they begin to develop this. Their development agreement suggests that they're going to do the retail section first. So if we look at this next map, all this retail, commercial property up here is what it was proposed to be started first. So that is all of the frontage there in 491. This is Hampshire Boulevard. This is the lot that Commissioner Bays, Mike Bays' husband, or Mike Bays owns, Commissioner Bays' husband. So that's important to note because this intersection here is going to line up with Hampshire. So now Tuscany Ranch is on the hook for putting this project in, putting in the stoplight and helping to get that done. Why is that important? Because again, Commissioner Bays' husband owns that property that's going to benefit from that traffic signal. It's also going to benefit from the expansion of 491 at the Tuscany project there, because now all of this property becomes immensely more valuable now that there's a build out across the street, particularly with the commercial build out here. So let's jump into this. This is that first lot here. This has shown you here that back in the, April 14th, 2005, this was purchased from this Alta Terra LLC. Again, this I'll show you in a second. This is Mike Bays' company. This parcel here and this parcel here. So both parcels are owned by him. Now, in the state of Florida, there's some concerns here with the ownership of the property with the husband and things like that. So Chronicle article had referenced the 491 project. They had asked Commissioner Bays if she had planned to skip the vote, and she said basically no, because her husband owns the business. It's not her business, and she can't skip the vote for that. However, I showed you state law that says that she's required to skip the vote if it's going to help a spouse in this particular case. That being said, she said she was not going to abstain from voting because of the widening and all the stuff that's going to go on here. This is the title work that was done to show you that they own that property. This is the Sunbiz screenshots. So this is Alta Terra LLC. This is the company that owns the building. You can see here Mike Bays is a registered agent. Mike Bays, authorized person manager with a title of manager here. Now, something else that I found as I was researching this is Mike Bays also owns a tanning salon that is there in that same plaza. So not only does he own the plaza, he also owns a business that is going into that plaza. Here's the address. They forgot the E for whatever reason. The mailing address, this is Mike Bays' State Farm office there in Beverly Hills. Mike Bays, registered agents, and some partners that are down here. He's also listed as the managing member here. Now, this is work that is being done for that building. You can see here, this is going to be a change of occupancy to a tanning salon. So they're doing permitting work inside the building, electrical, some drywall stuff, things of that nature. Here's the address to show you that it is that same address. So not only do they own the plaza, but they also own a business that's going into that plaza that's currently under construction to renovate that space. So who benefits from more people across the street from the property? Obviously, the people who own the building and the people who own a business within that building. So this benefits them in that extent. Now, again, talking about state law, there were some issues raised with someone asked me, it's not her business, how does that work out? So state of Florida isn't a community state to where everything is split evenly and all those things. There's special rules and things like that. But for the most part, if something was to happen to the spouse who is a business partner with somebody else, the business on their LLC agreement would absorb the portion of her spouse, so Mike Bays' portion, if something was to happen to him. However, in Florida as well, the spouse gets at least 50% generally of the estates, even if there's kids from other marriages and things like that. So that goes back all the way to 2005 when they created the business. I believe the Bays were married at that point in time. So the benefit to her directly is that if his business is successful, they make more money, obviously. So that money goes to her through him, kind of thing. And if they were to get a lot of property value, they paid $1 million for that parcel back in 2005. If that goes up immensely because of the growth and because of the eminent domain action that may occur, you heard her mention that, they stand to benefit greatly from that, particularly her spouse as a 50-50 partner in that building. So this is 491. I'm going to show you a couple different parcels along 491. This is down by Horace Allen. So this is all of just up here is the Walmart Plaza here. This is a parcel of land that just sold in October 2024. If you guys follow along with the PDC and some different things, this is that piece of land that was going to be, I think there's going to be a Quick Care Med here. There was talking about being a Chick-fil-A and all of that. So they parceled these out. They got these split into individual parcels. They sold this parcel for $1.8 million. It's 1.1 acres of land, and nothing is on it. So that shows you the immense value of real estate on 491, particularly in this area that's going to be developed. Citrus County owns some of these parcels over here, but some of these are for sale. I think Taco Bell just bought one of these. This parcel of land here was purchased by Citrus County in 2022 for $300,000. This is for the expansion of 491 and the Horace Allen intersection. Now, a couple years ago, we saw in the news the county was purchasing one of the Commissioner Slaybaugh's properties for $335,875. Now, that piece of land is this little parcel here. So this was $300,000. You can see here back in 2002, they bought this piece, and this whole piece back here for about $300,000. So she got her investment back in just this piece of land that was 0.83 acres there. And for whatever reason, the county didn't buy this piece here, so they still own that piece there. But I'm showing you these because when the county is involved with purchasing land for eminent domain and things of that nature, this was all purchased because of the expansion here for Horace Allen intersection there. There's immense value in that land. So now again, this one's $1.8 million. These ones I have no idea. They're going to skyrocket in value because they put this lane here. So Horace Allen is very similar to what Hampshire was back then. So Horace Allen is a kind of popular road here to get back into 44, which is down around this side over here. So they did the light there at Horace Allen. Everything else skyrocketed in value around that, obviously because that was sold for $1.8 million. So we're going to see the same thing happen with Hampshire. Once they start putting in Tuscany, once they put in the commercial things, once they put the light in there at Hampshire, that's going to cause that property to skyrocket. And again, Commissioner Bays' husband owns that. So there's a clear benefit to her for approving that project. Now, you saw her hem and haw all night about that, so take that for what you want to. But I still feel that she should have abstained from the votes because of the clear conflict of interest. And again, state law required her to step away from that vote because there was a financial interest for her husband, which was a relative under state law. So a couple questions to ask us with this. How does any of this get resolved? So there's a few different ways that this can end up going. More than likely, this is done. I don't see many of these things happening. Maybe some of them will, some of them won't. We'll talk about each of them here in a second. But for the most part, this is going to be done. I think this project is finished, but I wanted to put this out there for everyone to see and take it, what you want from it. But I'm about the optics and the transparency in government. I wanted everyone to be able to see what is going on here that you guys may not have known about previously. So what are the ways to get this to change? The number one way, and probably the easiest one to do, is for someone to file an ethics complaint. What that will do then is allow the state ethics board to go through the case. You could reference, hey, they own property on 491 that's going to benefit greatly from this project that she was voting on, making a vote for that particular project. And so then the ethics board would look at that, to look at state laws, how all those things relate. They would call, if they feel that there's a good case for that, they would call her in for to present her case, basically, to say why she shouldn't have been exempt from that vote and why she took that vote and was able to take that vote. Now, I don't know what enforcement power the ethics board has. I don't know if they can go back and decide, if they see this, be like, hey, that's a clear conflict of interest. She should not have voted on that. We are going to take her vote away from that action, and now it's a 2-2 vote from there. I don't know if they have the authority to do that. But they can certainly make that recommendation to the BOCC or to other agencies or whatever it is for that. Option number 2, this can be brought to the county. This, if 2 commissioners that were on the winning side, or a single commissioner was on the winning side, so you'd be looking at Commissioner Bays, Commissioner Kennard, or Commissioner Davis, they can likely get the county to appeal this decision. And maybe even one of the other commissioners might be able to do that. Now, with quasi-judicial stuff, there's different parties. So the applicant is one party, the county is another party because they're presenting a case, and then if there is an intervener, that would be a third party, or more parties if there's more interveners. So each party has the ability to appeal a decision from the BOCC. So had Tuscany lost, they could have appealed this to the court system. It's a civil appeal. It goes before a judge. The judge decides if there is reason to do a new case because of prejudice or whatever, and then they can order a new case to be heard, or it can say, hey, BOCC approval stands or disapproval stands in this case. The county also has that appealing option. The difficulty with the county appealing it is that it would come from the administrator, Steve Howard, and I don't see him honestly deciding to appeal this decision because of Commissioner Bays, because he probably doesn't want to lose his job, and going against the board would kind of give people reasons to remove him from his position for that. So he likely doesn't bring that up, and he likely doesn't file the appeal, although he has that ability to be able to do that. Now, again, just because they file appeal doesn't mean that they get heard, or doesn't mean that it's an automatic new case or anything like that. Someone else could file a lawsuit. What happens here is someone who has standing, so someone who presented at the meeting, who came to the board and said, hey, this is why you should approve or not approve the case. Someone that's at adjacent landowner can appeal. So someone who lives in Beverly Hills or their property backs up to this property is able to appeal the decision. Now, in order to do that, they have to file a lawsuit that goes through the civil courts there. I don't know the exact process of how it works, how much it costs, any of those things. But there is a risk for significant costs, because if they lose the case, then they have to pay for attorney's fees and all of those things. But that is an option for that, is that a party is able to file a lawsuit. They can reference that Commissioner Bays was not supposed to be taking a vote based on state law. And if that's successful, then they do a new case with Commissioner Bays no longer able to vote in the matter. In the event of a tie, it's a failure, so to speak. So had Commissioner Bays not voted, it would have been 2-2, and then it would have failed to get approved, and they would have to bring it back at some other point about a year later. The fourth option, again, this is a stretch on this one. I don't see this happening at all. But the BOCC can redo the hearing. Now, there's some procedural steps for this. I'm not exactly sure how they work. But basically, one of the 3 winning side commissioners, so again, Bays, Kennard, or Davis, is able to bring this up at the next board meeting and say, hey, we want to revisit that vote from the Tuscany vote, and we feel that Commissioner Bays should not have voted on that matter. We want to revoke our approval and issue a new hearing, or I guess just revoke the vote, which would then trigger appeals and all those things, which would then probably lead to a new hearing. So again, that would take one of the winning commissioners to step up and say, hey, this isn't right. She should have recused herself from this, and then taking that action to change the vote, so to speak. Again, I don't see that happening because that kind of creates chaos, and these commissioners don't necessarily like chaos. So I think, like I said, I think it's done deal, but there are 4 different options. There might be other options that I'm missing. The most likely of these to be successful, if anyone is interested in pursuing this, would be the ethics complaints, because that will get seen by somebody. If they feel that it's a valid case, then it gets escalated from there. Now, again, the issue with that is potential legal fees. Should Commissioner Bays hire an attorney to represent her at the ethics board and all those things, the state has the ability to determine if lawyers' fees are applicable here. So a risk there. But again, I think that this shows clear potential bias in the very least. So according to the quasi-judicial exemptions on the vote there, she should have stepped away just from that portion of it. But again, I think that state law also dictates there that she should have stepped away from the vote, not taking that vote for Tuscany. So let me know what you guys think in the comments, and check back later for more videos on other things that are coming later this week.